Hello there, and good morning, everybody. Welcome along to this session. It's good to see a few of you here. It's not the highest of turnouts at the moment, I think, to be honest, because there's lots and lots of people on holiday at the moment, making the most of the bank holiday weekends and stuff. So, a slightly smaller group today, which is always nice because it gives us a bit more time to explore things like questions and stuff in a bit more detail. Um, As ever, this session will be recorded, so if you need to leave early, or if we run over on time, or if you want to recap on anything, I will, of course, share a recording of this afterwards. Obviously, what that does mean is that if you kind of put anything in the chat or ask any questions in the chat, it might well get read out, and I might well read out your name at the same time as well. So please either post it anonymously if you don't want me to do that, or just ask me any questions you'd like to separately outside of the session. But if you're happy for us to kind of go through your question and have it recorded, then of course we will do so. So just briefly by way of introductions for anyone who's not been on one of our sessions in the past, we're Smart Clinic. We're an occupational health provider, of course. And we are the HR Ninjas partner for occupational health. So we have the good fortune of being able to speak with a lot of the lovely ninjas to talk about all sorts of occupational health matters. Now, of course, we do work with a lot of you. There will be people on this call today who are clients of ours. There will, of course, be people on this call today who are not clients of ours. Both are absolutely fine. This is not about it's not about selling. It's not kind of shameless promotion or anything like that. It is purely just trying to help and trying to assist. Occupational health can be a bit of a funny industry from time to time, and we can be, I appreciate, a touch unpopular with employers or a touch unhelpful with employers sometimes. So at Smart Clinic, we're here to try and kind of break down those barriers and kind of improve the stigma of occupational health a little bit. And one of the best ways of doing that is just helping. So I'm always happy to help. I'm always happy to provide advice, support, review stuff for you if you want us to, anything like that. So hopefully today will be a little bit about that. What I would say is this is the first time we've ever delivered this session. So please be gentle with me. I'm a touch nervous about it, but we will see how we get on. Because it's the first time we've done it, I'm not entirely sure how long this is going to last for. We might be well under or well over the half an hour, but please bear with me either way. As I say, if we do end up running over, the session is recorded, so you can always catch up with it if you do need to leave early or anything like that. Primarily, the reason that we've kind of designed this session and the purpose of it is to look at some real life complex cases where occupational health and human resources interlink, and instances where HR might need the support of occupational health or perhaps should have got the support of occupational health. We'll go through one of those cases. Um, and to see how you guys might use that and what that might translate to in terms of employment law and kind of managing complex cases. So we've taken three real life scenarios. None of them are us, I hasten to add. For the sake of confidentiality, I've not used any Smart Clinic cases. There'll be one or two examples that I use that are Smart Clinic examples, but the three cases that we're going through are not us cases. They're all cases of tribunals or employment appeal tribunals. So they're good ones to learn from. Um, yeah, and they all have reference to occupational health, or perhaps not, and should have done. What I would say before we kind of go into the three cases is clearly the vast majority of instances where occupational health and HR overlap, particularly those where things have gone wrong and or possibly have gone wrong, and therefore have ended up in a tribunal. One of the most common bits of legislation that gets cited is the Equality Act. I'm not going to kind of patronize you guys. You'll be just as familiar with the Equality Act as we are, so I'm not going to go through it in immense detail. This is just a quick recap about two of the most important points of the Equality Act that will be relevant to today's session. You will be well aware of them already, so this is just a recap, not kind of a learning piece. But the Equality Act, of course, is the primary piece of anti-discrimination legislation for employers in the UK ever since 2010, when kind of the previous discrimination legislation all got merged, things like the old Disability Act and the Age Discrimination Act and the Sex Discrimination Act and so on. Now, from the point of view of today, we're basically just talking about the disability element of the Equality Act because obviously we're an occupational health company and we're mostly talking about complex cases in terms of medical issues. So just to recap, so an employee would be considered to have a disability under the Equality Act if they have a physical or mental impairment. So there's the first important bit. We're both talking about physical health and psychological health. That impairment, and then notice it doesn't say diagnosis, it doesn't say condition, it says impairment. In other words, something that impairs somebody's sort of day-to-day working, ways of operating their health. That impairment needs to have a substantial and long-term negative effect on their ability to do normal daily activities. So that's not necessarily something that might preclude them from doing abnormal activities. Just because somebody can't go windsurfing as a result of a health condition doesn't necessarily cover them under the Equality Act. However, if it has an impact on their ability to, for example, wash themselves or work normally, or get dressed in the morning, or feed themselves, or travel, or any other kind of daily activities, then it would be considered. So it needs to be substantial and it needs to be long term. Interestingly, the Equality Act is considering what somebody's health condition, how it affects them without medication or without treatment. So just because somebody takes medication that does improve their symptoms, that doesn't necessarily mean that they would not be covered under the Equality Act. That is particularly relevant when it comes to neurodiversity, which is the final case. Spoiler alert, it's the final case that we're going to go through. And long-term typically means more than a year. There are one or two exceptions to this. There are, for example, cancer is automatically covered under the Equality Act. We're not going through any cancer cases today, so that's not relevant. But that aside, they are the conditions that need to be met for someone to be covered by the Equality Act. As you all well know, it's not a decision that you can make. It's not a decision even that we can make. It is only a decision that a judge can make at an employment tribunal. Now, typically, you would take occupational health steer on whether somebody is likely to be covered by the Equality Act, but we can't give you the black and white answer to that because we're not allowed. Nobody is allowed. So it is something, unfortunately, you tend to not know a black and white answer to it until it's too late, which is not necessarily the best way around of doing it, but that's what we're stuck with. Now, if somebody is covered by the Equality Act, you as an employer have the obligation to provide reasonable adjustments. We'll not go into this in much detail because you probably know what that means, but very quick summary, that means that you need to adjust somebody's working role in a way that you as an employer determine to be reasonable. Now, obviously, that is quite subjective, and what is reasonable will differ from different employers. Big companies with large budgets and lots of departments are likely to be able to make more adjustments and more accommodations than, for example, a small business with 5 staff. The two would be treated very differently, but that's why the word reasonable is deliberately subjective. So enough about the Equality Act for now. Let's go on to some case studies. I should add, by the way, as well, as we go through these, if you have any comments or questions, or just generally feedback, to be honest, I'd find that really useful too. Please do put them in the comments section. I'll probably address them at the end, but please do feel free to put them in now, just in case you kind of, worried about forgetting to ask them later. So this is a real case of performance management. We're going to call the lady Sharon. She's not called Sharon, but we'll call her Sharon for now. This is the case of a telesales worker who works for an insurance company. She worked at that insurance company since 2016, and her job was effectively in telesales. So she had to convert sales leads, so typically that's quotes, into sales. In other words, she'd probably be ringing people back who got quotes and trying to convert those quotes into sales. For the first few years, she was very, very good at her job, had extremely high conversion rates, and everything was going well. Everyone was happy. However, from late 2019, there were some concerns raised about her performance, primarily her performance in terms of she just wasn't converting enough sales. So her sales numbers dipped. In 2021, she was placed on an placed on a formal performance management process. a performance improvement plan or PM or something along those lines. This also coincided with her suffering from symptoms of the menopause. This included memory issues, concentration problems, low mood, and anxiety. These were all reported symptoms. Off the back of this performance management, she resigned from her role in 2022, so about a year or so after she got put under performance management. Following her resignation, she made claims of constructive dismissal and disability discrimination. This was mostly on the basis of the fact that she had a health condition, and instead of the health condition being taken into account, they purely went down the performance management route without considering any mitigations for her health condition. She took this to an employment tribunal. This didn't reach an EAT. This was just an employment tribunal. I think, actually, I better check that, but I think that's the case. And she was awarded £65,000 in compensation, and the entire process took 4 years from start to finish. So there was a lot of wasted time and resources and money on this situation, which clearly, had this situation have not occurred, 4 years could have been saved and a lot of money could have been saved. So where did it go wrong? Well, there are things that we need to learn from this case. Probably the most significant is that, firstly, you don't need to remove all performance expectations. This is made very clear in the employment tribunal. It's fine to manage people who are underperforming, irrespective of whether they have a health condition or not. You don't need to remove all performance expectations for somebody who is covered under the Equality Act. However, you should consider supportive measures or potential adjustments, for example, to the performance expectations before or alongside the performance management measures. In other words, support first, management later. This was a very, very clear outcome from the tribunal, and this is what the primary area of criticism against the employer was, that the employer didn't consider any of the health conditions or any supportive measures. They went straight to performance management. They didn't use occupational health, and clearly, had they have done before going down the performance management route, occupational health would have been able to provide them more background about the health conditions, which in this instance was early onset menopause, and the associated symptoms. They would have been able to advise that the employer was likely covered by the Equality Act, and they would have been able to advise on some adjustments that the employer should be considering prior to making any management-related decisions. Now, one of the reasons that they should do this is, of course, if the employee is struggling, then making adjustments might actually help them, and it might bring their performance back to an acceptable standard anyway. It might be, for example, that making some adjustments would help to bring them back to what their target expectations are, whether it's kind of sales leads or conversions or whatever their particular job is. So actually, they might have been able to resolve the problem before it was a problem anyway. Of course, if that wasn't the case, then at the very least, the employer has attempted to support the employee and make the adjustments required. From the point of view of the Equality Act, they would have helped that employer to overcome the disadvantages suffered as a result of their protected characteristic, disability in this case. And this was the primary kind of downfall in terms of this case. Because the employer didn't do this, they didn't make any endeavours to kind of make any adjustments or provide any to support to the employee. Had they have done that, they could have considered all sorts of things. They might have considered, for example, adjustments to workload and targets. This might have been, and none of this is a prerequisite, but by the way, these are just examples. But it could have included reviewing their sales or conversion targets, for example. It could have made sure that the metrics focused on quality of the calls rather than the quantity. It could have it could have allowed them larger than average call handling time to compensate for any kind of fatigue or concentration. It could have reduced some kind of non-essential administrative tasks, maybe making notes on the system or follow-up emails or something. Um, there could have been flexibility in working hours, earlier start times and finish times, for instance, to help manage fatigue. It could have included longer or more frequent rest breaks. It could have included part-time hours or reduced hours temporarily while the symptoms were particularly acute. It could have meant changing the environment. It could be that the temperature control of the environment needed adjusting, for example. It could have included making easier access to rest areas, and so on and so on. I can talk about potential adjustments all day long. Unfortunately, we didn't assess this case, so I don't know exactly what adjustments would have been relevant to this person, but these are just some of the things that occupational health might have considered as recommendations, and therefore should have been considered by the employer. Of course, as none of these were considered, they went straight to performance management, and this constituted a breach of the Equality Act. In other words, they discriminated against the employee on the grounds of health and disability. It was very messy, created a lot of problems to the employer. Obviously, it was very unpleasant for the employee themselves too, and it all could have been avoided. And simplistically, it could have been avoided just by engaging occupational health right at the start, following some recommendations, and just being a bit more supportive of the employee. That doesn't mean removing all expectations and all targets, as we talked about. It just means a bit of extra support to the employee. The summary learning from this one, and here's some references, by the way. The case that we just talked about is the first one on that list, but the second and third cases on that list also corroborate this point as well. Well worth having a flick through these, even if you just read the summaries of the cases. But the summary learning from this one is support with health conditions before performance management or any management decisions. And that's applicable to all walks of life. That's applicable to any other management decisions you might make as well, such as disciplinary processes, dismissals, and so on. So the second case we're going to go through is a case of Mo. Again, not real name, but this is a real case. This is a case of somebody who's got high absences. So Mo works for, I believe, HMRC. In fact, it is HMRC. He's a caseworker who investigates financial conduct. Mo suffers from anxiety and depression, and it was confirmed that he is covered under the Equality Act, or at the very least, at the time that the employer knew about it, that he was likely to be covered under the Equality Act. However, over a 3-year period, he had suffered from 23 separate absences. They weren't particularly long-term absences, but they were, of course, in terms of instances, very, very high. It's probably fair to assume in this regard that the vast majority of the people on this call will consider that to be in breach of their absence management procedures and therefore an unacceptably high level of absences. HMRC certainly did take that view. Consequently, the employee was dismissed in 2018. So what went wrong here? Well, actually, nothing went wrong. This went to an employment tribunal. The employment tribunal sided with the employer. The employee then appealed that, and it went to an employment appeal tribunal. They upheld the case. They upheld the decision, sorry, in 2021. In other words, both the employment tribunal and the employment appeal tribunal dismissed the claim. That was because the employer had pursued legitimate aims. They took exactly the correct steps to manage the employee. The steps that they took were entirely proportionate to the problem that they were facing, and the employer had already considered all reasonable adjustments. They'd engaged occupational health nice and early, and actually several times. They'd considered all of the recommendations that occupational health had recommended. They didn't make all of the recommendations because some of them they constituted not to be reasonable, but they evidenced why they weren't reasonable, and they did make the adjustments that they did consider to be reasonable. Therefore, they had followed and enforced a fair absence management policy. So let's break that down into a bit more detail. Why did the employer actually get it right in this instance, and why was it fair to dismiss somebody on the basis of multiple absences? Well, firstly, they had a very clear absence policy. That absence policy described what level of absence is acceptable and what level of absence would put them onto the stage 1 of the absence management policy. They then made it clear what the expectations were from stage 1, and if those were failed, they made it clear what the consequences would be, and the consequences were that they would move to stage 2 of the absence policy. Same goes from moving from stage 2 to stage 3. They made it clear what the expectations were. The employee didn't succeed in those expectations, and therefore they moved to stage 3, which was dismissal stage. So they had a good, robust absence policy, and they followed it. That absence policy also included the involvement of occupational health at the appropriate stages. Now, HMRC actually really used occupational health a lot in this instance, more so perhaps than they needed to, but they were going belt and braces, which is good, albeit they probably could have got away with using OH a little bit less if they'd have wanted to. However, what they did do is they involved OH early, and this was key. This was absolutely key to the case because it meant from the very, very early stages, they gave all the support and adjustments to the employee that they could do to help the employee be successful in their attendance. So, in other words, they did everything that they could, or everything that was reasonable for the employer to do. As such, they implemented what they could in terms of reasonable adjustments, and all were considered. Some were applied, some weren't applied, but where they weren't applied, they evidenced why they weren't considered to be reasonable. Occupational health at the latter stages also concluded that fitness to work was uncertain and a regular return to work in any capacity is uncertain. Not great wording, if I'm perfectly honest, from an occupational health report. That's probably not the wording that we would have used. We probably would have said unlikely or not possible or something along those lines. However, the employer quite rightly took uncertain to mean unlikely. In other words, the member of staff is unlikely to be fit for work now and also unlikely to be fit for work at any point in the in the medium term future. In other words, the employee is not going to be able to achieve the attendance levels that HMRC needed them to. As we talked about, HMRC offered support throughout. They even looked at alternative job roles to see whether an alternative job role was available. It wasn't, but they did help Mo with trying to seek that. When making the dismissal, they also, when making the dismissal, the employer concluded that they had already exhausted all the reasonable adjustments that they could have done. They documented this in their dismissal decision. They also documented that continued employment wasn't sustainable and was having too much of a detrimental operational impact on them. And therefore, they needed to dismiss the employee to maintain efficiency and fairness across the workforce. Not a nice decision. However, as you can see from everything that we've been through, this was a decision that they didn't take lightly, and it was the absolute last resort for them. They went through all of the appropriate supportive measures and absence management measures that they needed to in order to get to that decision. So the learning from this case is you can dismiss somebody, even if they're covered by the Equality Act, for health reasons, capability reasons, for reasons, for example, of multiple absences, so long as you follow the appropriate procedures. The appropriate procedures include, amongst other things, involving occupational health at the early stages and also probably at the decision stage as well, just to get a confirmation of kind of the next steps in terms of whether they're likely to be able to work again in any capacity in the near future. Now, that case that I've just been through, again, that's the top case, McAllister versus Revenue and Customs Commissioners. In other words, that's HMRC. However, I've also included 3 other tribunal rulings that all follow a reasonably similar pattern and come to reasonably similar conclusions, and kind of corroborate some of the points that we've discussed in that particular case. So that concludes case study number 2, which is one to do with high absences. Case study number 3, arguably the most controversial one of the 3. This is something that we continuously are learning on at the moment. We all are. There's case law coming out on this almost every day at the moment. So we're going to base this on some relatively recent findings and everything that we know so far. So this is a case of neurodiversity affecting behaviours, and it's an individual who, and before anybody accuses me of being inappropriate, the member of staff themselves calls themselves Aspie. This is actually a key point of the case. You'll see why shortly. Aspie is in reference to Asperger's syndrome, which is the old name for autistic spectrum disorder. These days, when you hear the phrase autistic spectrum disorder or ASD, that's often what people used to call Asperger's syndrome. Aspie is a colloquial term for that, and the member of staff herself calls herself Aspie, and she self-identifies under this name. This is relevant to this case. You will see why shortly. So Aspie was a teacher in a special school. I've already mentioned she calls herself Aspie in recognition of the fact that she was undergoing diagnosis for ASD. Note undergoing. The diagnosis is not yet confirmed. This is also an important point. She was dismissed for I think it was gross misconduct. Don't quote me on that, albeit it doesn't really matter. But she was dismissed for sending abusive and inappropriate emails, both internally and externally, internally to colleagues and externally to parents and governors, and also the local authority as well, the local educational authority, which this was a local educational authority maintained school. So in other words, they're the boss. The content of the emails was considered to be aggressive, hostile, and accusatory. This is the wording from the Employment Tribunal. They contained disparaging remarks about colleagues and undermined professional relationships. Again, that is the wording from the Employment Tribunal. Just some of the examples of the wording from these emails included, "You don't own my mouth," she said, and "stuff your disciplinary." I can't obviously say all of the content of the emails because it's not appropriate even on a work webinar, but these are some tamer examples. She also sent some sexually explicit text messages to her colleagues. Again, let's just use our imagination on that one. Now, this was understandably considered to be significantly in breach of what can be considered to be fair and reasonable conduct by the employer, and they went straight to dismissal stage. Aspie then took them to tribunal on the basis that the dismissal was unfair on the grounds of disability. In other words, it was disability discrimination. Now, she claimed that it was unfair on the grounds of disability because she was going through the process of getting a diagnosis for autistic spectrum disorder and self-identified as being a sufferer of autistic spectrum disorder or Asperger's syndrome. Hence, she called herself Aspie. Now, one of the significant and kind of unusual quirks to this case is that the employer denied having any constructive knowledge of the employee having a disability at the time of the dismissal. The reason for this is that they stated there was no formal diagnosis, which is correct, there was no formal diagnosis, and the name Aspie was too informal. Interestingly, the Employment Tribunal agreed with the employer here. They actually said, "You're right, there was no way that you could have known." However, and significantly, the EAT actually overturned this point, stating that the employer should have known that the employee had a disability. The reason for this is that there were self-disclosures. The employee, for example, had declared to their employer that they were undergoing the process for getting a diagnosis. They called themselves Aspie, as we've talked about already, and they even brought in a birthday cake with the name Aspie on it, again clearly making reference to Asperger's syndrome, or autistic spectrum disorder as we now call it. Therefore, the EAT should have declared that the employer should have known and should have had constructive knowledge. However, this actually ended up being a moot point. The reason for that is that the EAT agreed with the employer that the misconduct was so serious that going straight to dismissal was a proportionate response. Now, what's interesting here, and that in a normal scenario where there was no health considerations or no considerations under the Equality Act, under a normal scenario, there's probably not a person on this call who wouldn't say, yeah, abusive emails, that could well constitute dismissal. That's absolutely fine. However, where a health condition comes in, are we on shakier ground? Well, a lot of people would say, gosh, they're covered by the Equality Act, we can't really touch them. This case proves otherwise. This case proves that if somebody is covered under the Equality Act, then that health condition or neurodiversity condition does not justify inappropriate and disproportionately inappropriate behaviours. That is a significant point. And whilst we're talking about neurodiversity here, because that's one of the things that can impact behaviours most significantly, in actual fact, that goes for any condition that could be covered under the Equality Act. Just as a slight side note here, by the way, coverage of neurodiversity under the Equality Act is a complex matter. We're going to go through an entire session about this a little later in the year. Again, we are all learning every day about this particular point, so it's useful for it to be in a month or so's time, because there are a couple of pending tribunals that might change how we consider these matters. But for now, just consider that in this instance, at the very least, neurodiversity was covered as under the Equality Act. Key learning from this is that a diagnosis is not required for an employee to be covered under the Equality Act. If we go back to the wording of the Equality Act, that's understandable. There's no reference whatsoever to a diagnosis in the wording for the Equality Act. It talks about an impairment being long-term and affecting day-to-day abilities. It doesn't talk about what you call it. So a label or a diagnosis is not relevant. It's the symptoms, it's the functioning, it's how it impacts people that is relevant. So from your point of view as an employer, if somebody self-declares as being neurodiverse, however much you believe them or disbelieve them, you need to take it seriously. And you need to start considering how that may or may not, in fact, impact upon their day-to-day living. And that's the reason for which it's quite useful to get some external input in the early stages. Occupational health is the most common and most popular and probably the best way of doing that. But there are alternatives as well if you wanted to look at specialist neurodiversity companies like Lexic, for example, or getting further information from the GP. They tend to be much more expensive and much more long-winded, so usually occupational health is probably the easiest and most helpful place to start. But yeah, as I say, there are other options too. Yeah, so that kind of takes us on to the second point on this slide, actually. So employers shouldn't ignore self-disclosures. That's not to say that the self-disclosure is correct or accurate, but you shouldn't ignore them. You should take them seriously and see what that might mean to you. It's difficult. It's really difficult for an employer. I feel for you. Anyone could walk into your office tomorrow and say, I think I'm ADHD, or I think I've got Asperger's or autistic spectrum disorder. Unfortunately, you've got well, I don't know if it's unfortunate or that's not the right word, but it makes it difficult for you that irrespective of how much you believe them or disbelieve them, or whether they're right or not, from that point onwards, you do need to take that seriously. And probably get third-party advice, which I feel for you. It's not easy, but we've got to look at the case law here. And thirdly, being covered under the Equality Act doesn't excuse misconduct. We do have plenty of examples, actually, of cases that we have dealt with internally here at Smart Clinic. I am going to be very careful about what I say here, but I'll give you 3 examples just in the last month of cases that we have dealt with where the employee's health conditions possibly do explain their behaviours. However, they do not possibly constitute reasonable excuses or mitigations for their behaviours, or nor do they necessarily make them acceptable in the eyes of the employer. Here are 3 examples as to why. One case we dealt with recently was about an employee who worked in a shop. Clearly, I can't say which shop, but they worked in a shop and they were being very abusive towards their customers. They had a psychiatric diagnosis. Irrespective of the diagnosis, the employer could not maintain an employee who is abusive towards customers. Clearly, they can't do that. It puts everybody at risk. It's not fair. Another case that we've dealt with recently is about a teacher who was making sexually inappropriate and explicit comments to their students. They were 6th form students, but nevertheless, they were still making sexually inappropriate comments to the students. The employee did have a confirmed neurodiversity diagnosis. That does not mean that they can continue to make sexually explicit comments to children. And the third instance we dealt with recently was about a call centre worker who was refusing to answer inbound calls. it wasn't an adjustment at this stage. They would just sit at their desk and not answer inbound calls, despite it being their job, stating that they had anxiety and that they just would not be answering calls anymore. These are clearly all very difficult scenarios for the employer, and they're all scenarios where the employer has said this is not a behaviour that we can tolerate, regardless of whether there's a diagnosis or a medical explanation or not. Another one, this is not a particularly unique case that we've had recently, but I know is a hotly debated topic, is cameras on. To what extent do you mandate cameras on as part of your Teams meetings or Zoom meetings or Google Meets or whatever? And to what extent can you accept cameras off if it's on the grounds of disability and health conditions and things? I'm not going to give you an answer to that because there isn't an answer to that, but it's a quite common day-to-day consideration in terms of behaviours that you may or may not consider to be acceptable, irrespective of whether they've got a health condition or not. So that's quite an interesting point. There is quite a lot of I've deliberately put quite a few cases on here, quite a lot of case law, because this is quite a difficult legal matter. So to be honest, we're having to sort of piece together guidance from quite a number of different tribunals and bits of case law and stuff. So I've cited a few of them here. When we come to our specific session on neurodiversity, then we might explore some of these in a bit more detail and what some of the learnings are. The one that I mentioned there was the top one, Kayla versus Insight CSC, but a lot of these kind of corroborate some of the points that I've been talking about as well, and explore some of the kind of unique parts of what I've been talking about in a bit more detail as well. So a few of them are well worth a read. The Peloton one is particularly interested. That is Peloton, as in the bicycle people as well. So it's quite a high profile case. I'm sure many of you have heard of Capgemini as well. So that brings me to the end of the session. I apologise for running over a little bit. As I say, it's the first time I've done one of these, so I wasn't entirely sure how long it was going to last. And yeah, we have gone a few minutes over, but I hope it was useful. I quite enjoyed going through that, actually. I'm very interested by case law, and clearly as an occupational health business, a lot of the decisions that we make and the advice that we give, and also the ways that we structure our services and our protocols and things are rooted in case law. So we're always scouring tribunal decisions and legal guidance and things when we give our advice. So everything I've said today is rooted somewhere in law. If there's something that you want me to kind of explore or go into a bit more detail on, or perhaps give you a little bit of the rationale for or the case law on, I'm always happy to do that. Appreciate we might be a bit limited by time, but the offer stands indefinitely if you did ever want me to go through stuff. That aside, I'm done. So if you did have any questions or any comments or anything like that, please do hit me up with them. I've not really been keeping an eye on the comment section, so I'm going to have a quick look through. Susan, I'm going to read out your question because it's quite a long one. I hope you don't mind. There's a long-term sickness case where the employee had been away from work for a significant amount of time, for over 18 months, with multiple health conditions, and is reaching the final stage of the procedure. Interesting, so we've got a few things going on here already, haven't we, Susan? HR have referred the employee to OH on several occasions. The OH keeps saying that the employee may be fit in 3 to 4 months' time at the next review, but it never materialises when the next review comes. Interesting. The pattern keeps happening. What can HR do in terms of OH as it's delaying the formal process? Yes, it is, Susan. Interesting question. I would be very interested to know who that OH provider is, whether it's us or not. Typically, the guidance in that instance would be that you need to set a target, and usually that would be our advice that we put in our reports, particularly if it's a physician-led referral, where we can be a bit more black and white and a bit more, I don't know, Grim Reaper-like. Don't want to be too macabre about it, but we can be a bit more final in our determination when it's a physician assessment. So my first kind of question would be, has that referral been with a nurse or a doctor? If it's been with a nurse, you might want to consider your next one being with a doctor if you have that facility. My second point would be you probably don't need to be reviewing every 3 to 4 months. I think that's an overkill. I think probably the sensible step forward from your point of view and what would typically be our advice in this instance is clearly 18 months is a really, really long time. The fact that you've been able to sustain that absence for 18 months already has demonstrated that you've been a very understanding and very reasonable employer. So you've already done quite a lot there just by maintaining their employment. However, we all have cut-off points. That includes you. So you'll probably identify a cut-off point for the stage at which you would say this level of absence is no longer manageable from our point of view. So in other words, you would probably target an identified return to work date, give them the target to achieve that. You might know full well they're not going to achieve it. You might even have passed that date. But either way, identify that target for return to work that you believe to be reasonable, because you quite understandably would say we can't carry on forever. That it is reasonable, by the way, for you to say that that date is in the past. In other words, we've already hit that target. Since the OH review has said 3 to 4 months, that's not short term, that's not 3 to 4 weeks. 3 to 4 months is a long time. That would take the absence to basically nearly 2 years. That's not the level of absence that you can sustain. So you've got to identify a cutoff point that's already been and gone, or you might say, look, we'll give it 1 more month or whatever, but you identify that cutoff point. You communicate that cutoff point clearly with your employee, and if and when they fail to achieve that, you would consider that the final stage of the absence procedure, which it sounds like from your question you've been following anyway. And then you would make the decision at that stage as to whether you wish to dismiss or not. You might choose not to, you might choose to, but either way, if you've identified that target, you have to manage the employee in line with that target. You can't go on indefinitely. And just because OH has said they might be fit to work in 3 to 4 months, that doesn't make it reasonable for you. That's just a guess. It actually sounds like it's not a particularly good guess as well, because it's gone on and on and on from the way that you're describing it. But nevertheless, it is just a guess. You, from your point of view, almost have to be a bit more identifying of the target with it. So that would kind of be my advice on it. There is plenty of instances of employers doing that and doing everything that they can, and ultimately making the decision to dismiss, and that being fine. So long as you've kind of gone through some of the things that we've talked about today, you've referred to OH, which clearly you've done a lot, which is good. You've tried to support them, you've tried to put adjustments in, you've tried to encourage them back to work. Again, you've probably done all of that. It sounds like you've done everything you need to. I think the final step is identify that target return to work date, see if they achieve it. If they don't, decision time. That'll probably be my answer to that question, Susan. Thank you for the nice comments, by the way, guys. I really appreciate that. As I mentioned, it's the first time I've done this session, so I'm really grateful for the feedback. Even if there's anything constructive or stuff you would have liked me to have gone through that I haven't gone through, always happy to hear that as well, because I'll adapt this continuously. As I'm sure we'll be delivering similar sessions for clients and things, so I'm sure we will adapt it as we go along too. But thank you very much for your time. In the meantime, I will, as I say, share this recording so you can look back if ever you want to and see some of the case law that I've put on the slides as well. But yeah, until then, thanks very much. Enjoy the lovely weather. And yeah, I'm sure I will see you on HR Ninjas soon. Take care.